You are always welcome home, welcome.
Today's news is about success stories. Ever since we introduced Abinelle Solicitors to you, there have been countless impactful stories from our clients. So if you are yet to experience the most promising law firm in London, welcome to the world of Abinelle Solicitors, where there's always timely intervention for excellent results. Abinelle Solicitors, we specialize in immigration and family law. So for immigration, come to us for nationality law,
EEA law, leave to remain, point-based system applications,
entry clearance applications, student visas, visitors visas, and all appeals and judicial reviews. And for family law,
come to us for divorce, separation, consent orders, child arrangement orders, financial orders, and mediation.
Come, let's do business. Our address is
14 Claypole Road, Stratford, London, E15 2RJ.
Please call 0203 759 3309 or 078 2470 5353 or 077 8732 7985. Our 24-hour emergency contact line is
079 4323 5364. Email info@abinellesolicitors.co.uk.
Abinelle Solicitors, timely intervention, ex-solicitors to you. There have been countless impactful stories from our clients. So if you are yet to experience the most promising law firm in London, welcome to the world of Abinelle Solicitors, where there's always timely intervention for excellent results. Abinelle Solicitors, we specialize in immigration and family law. So for immigration, come to us for nationality law,
EEA law, leave to remain, point-based system applications,
entry clearance applications, student visas, visitors visas, and all appeals and judicial reviews. And for family law,
come to us for divorce, separation, consent orders, child arrangement orders, financial orders, and mediation.
Come, let's do business. Our address is
14 Claypole Road, Stratford, London, E15 2RJ.
Please call 0203 759 3309 or 078 2470 5353 or 077 8732 7985. Our 24-hour emergency contact line is
079 4323 5364. Email info@abinellesolicitors.co.uk.
Abinelle Solicitors, timely intervention, excellent result.
To where you are always welcome home, welcome.
Today's news is about success stories. Ever since we introduced Abinelle Solicitors to you, there have been countless impactful stories from our clients. So if you are yet to experience the most promising law firm in London, welcome to the world of Abinelle Solicitors, where there's always timely intervention for excellent results. Abinelle Solicitors, we specialize in immigration and family law. So for immigration, come to us for nationality law,
EEA law, leave to remain, point-based system applications,
entry clearance applications, student visas, visitors visas, and all appeals and judicial reviews. And for family law,
come to us for divorce, separation, consent orders, child arrangement orders, financial orders, and mediation.
Come, let's do business. Our address is
14 Claypole Road, Stratford, London, E15 2RJ.
Please call 0203 759 3309 or 078 2470 5353 or 077 8732 7985. Our 24-hour emergency contact line is
079 4323 5364. Email info@abinellesolicitors.co.uk.
Abinelle Solicitors, timely intervention, excellent result.
To where you are always welcome home, welcome.
Today's news is about success stories. Ever since we introduced Abinelle Solicitors to you, there have been countless impactful stories from our clients. So if you are yet to experience the most promising law firm in London, welcome to the world of Abinelle Solicitors, where there's always timely intervention for excellent results. Abinelle Solicitors, we specialize in immigration and family law. So for immigration, come to us for nationality law,
EEA law, leave to remain, point-based system applications,
entry clearance applications, student visas, visitors visas, and all appeals and judicial reviews. And for family law,
come to us for divorce, separation, consent orders, child arrangement orders, financial orders, and mediation.
Come, let's do business. Our address is
14 Claypole Road, Stratford, London, E15 2RJ.
Please call 0203 759 3309 or 078 2470 5353 or 077 8732 7985. Our 24-hour emergency contact line is
079 4323 5364. Email info@abinelsolicitors.co.uk.
Abinelle Solicitors. Timely intervention, excellent result.
To where you are always welcome home, welcome.
Today's news is about success stories. Ever since we introduced Abinelle Solicitors to you, there have been countless impactful stories from our clients. So if you are yet to experience the most promising law firm in London, welcome to the world of Abinelle Solicitors, where there's always timely intervention for excellent results. Abinelle Solicitors, we specialize in immigration and family law. So for immigration, come to us for nationality law,
EEA law, leave to remain, point-based system applications,
entry clearance applications, student visas, visitors visas, and all appeals and judicial reviews. And for family law,
come to us for divorce, separation, consent orders, child arrangement orders, financial orders, and mediation.
Come, let's do business. Our address is
14 Claypole Road, Stratford, London, E15 2RJ.
Please call 0203 759 3309 or 078 2470 5353 or 077 8732 7985. Our 24-hour emergency contact line is
079 4323 5364. Email info@abinelsolicitors.co.uk.
Abinelle Solicitors. Timely intervention, excellent result.
To where you are always welcome home, welcome.
Today's news is about success stories. Ever since we introduced Abinelle Solicitors to you, there have been countless impactful stories from our clients. So if you are yet to experience the most promising law firm in London, welcome to the world of Abinelle Solicitors, where there's always timely intervention for excellent results. Abinelle Solicitors, we specialize in immigration and family law. So for immigration, come to us for nationality law,
EEA law, leave to remain, point-based system applications,
entry clearance applications, student.
Good evening, wonderful people. It's great to have you all here once again. This is the Legal Hour with Abinelle Solicitors, the only great solicitor in the whole wide world. Even though they are in UK, they do work everywhere. We want to say a massive thanks to Abinelle Solicitors. My name is MDA Mamedankwa Asante, and today I'm not going to be here alone. I'm going to be with Sawa and Abinelle, lawyer Amy. So we are going to discuss about child arrangement. That is what we are going to discuss today. So I would ask them to say hello to the fans watching us, and then we'll start. So we'll start with lawyer Amy. Can you say hello to your fans, and then we'll start.
Good afternoon or good evening. Thank you so much for joining us today on this special Friday. We're going to discuss some very interesting topics. So please stay tuned and keep watching, keep supporting us. Thank you so much.
Thank you, Lawyer Amy. Okay, so congratulations once again. She just got married, and I just want everyone watching her now to say congratulations to such a pretty lawyer. And so, Thomas, can you say hello to the fans watching you and say something to them? Fans, say congratulations to her. They've started already. Okay, so let's go.
Good evening, everyone. As you mentioned, my name is Shewa. Thank you all for joining us this evening. It should be a very educative session where we talk a lot about matters concerning specific people, and we hope that it will be helpful to you today.
Thank you, Sarah. Thank you so much. Sarah, have you got any updates for us before we start?
Yes, just a brief one. A recent case that I think we might have already discussed, but I want to talk on it a bit further.
Okay.
In regards to marriage of convenience. So when we talk about marriage of convenience, it's a marriage where two people come together, for example, maybe because somebody wants to get leave to remain in the UK. So we have this recent case that took place in August of a lady called Dora Nikita. And so she got married by proxy marriage in Ghana to someone who had an EU nationality but lives in the UK. So in this application that she was doing, they had to attend a marriage interview now. And it's separate. So this interview takes place separately. So when they both attended this interview, unfortunately, it was not successful. And they said that this marriage is one of convenience, which means it's not a genuine marriage. They don't think these people genuinely met each other, fell in love, and decided to get married. They believe it's because she wanted to use, his status to get her own settlement in the UK. So they discussed this issue, and she appealed. She appealed the decision, and basically was saying that the marriage is not one of convenience, but it's a genuine marriage. And after they looked through, the marriage, their history together, they actually decided that, do you know what? The marriage itself is now not one of convenience, but the original root of the marriage was one of convenience. So after they spent some time together, they actually have a child together, I believe, as well. So the marriage originally was for her own, personal use, for her to get her leave to remain. However, as time developed, they moved in together. The marriage actually developed to be a genuine relationship. However, they now had to decide, do we still, revoke the right for her to get leave to remain or settlement in the UK based on this marriage, now that it's actually genuine, or do we, allow her to stay, even though it's a marriage of convenience? However, after the appeal, they decided that because the root of the marriage itself was not genuine, unfortunately, they would not allow her to apply under this root as the spouse of an EU national who live in the UK. And unfortunately, she was not able to get her settlement based on that route, because the original root of the marriage, the original intention was not based on a genuine and subsistent relationship. It was actually for her to benefit from this person's EU nationality. So that's just a current update, just for everyone to be careful when you're going ahead, with your relationships. If you're trying to use that as a way to stay in the UK, you need to make sure that these relationships are genuine, subsistent. You can see this through maybe pictures together, how you met, knowing simple information about your partner's family. Do you know your partner's parents' names, for example? Things like that. These are kind of things that they will ask you in a marriage interview. Where do they work? Their date of birth. If you don't know those things, unfortunately, this could be
Thank
a
you so
situation.
much. Thank you so much for this great information. Lawyer Amy, do you have any updates for us, please?
Okay, so my update really is really, it's not really an update, but it's surrounding what we're going to speak about today.
Okay.
You see, MDA, we know a lot about the 10-year parent route, the 5-year parent route, based on a British child or a child that's settled in the UK. But there are other elements to it. It's not every single application that's the same. You have certain applications whereby, unfortunately, one of the parents, or maybe the parent applying for leave, does not have access to the children. But they're very much in the UK, very present, but they're not actually actively involved in the children's lives by no fault of their own. They still very much love their children. They want to be involved in the children's life, but they don't have the opportunity to do so. So today we are really going to discuss these points in depth, where you're being restricted. You're a parent. You don't have that access to your child, but you need to show the Home Office as well that you have sole parental responsibility for the child in question. So that's what we're going to discuss today.
Okay, thank you, Lawyer Amy. Sean, I'm going to talk more with you. What is child arrangement order? When we say child arrangement order, what does that mean? Someone might not understand it. What does that mean? Child arrangement order.
Thank you for that question. I'm going to try and make it as simple as possible. So child arrangements order is simply a court order that you apply for. So it decides where a child can live, who they can live with, who the child spends time with, so which parent. It's important to note you can only apply for this order if you have parental responsibility. What does that mean? That means you have a right to make important decisions regarding this child. In most cases, that's the mother of a child or the father who's on the birth certificate of this child. So essentially, when you apply for this child arrangements order, it might be a disagreement that two people have had in regards to how they want to bring up the children. One person doesn't have access to their child, so they will go ahead and apply for this court order. So before, it used to be a residence order and a contact order. That means residence only dealt with who the child will live with, where they'll live. Contact is who can see the child, when they can see the child. However, that's now been merged into one. So child arrangements order, you can apply for both under this order. And this is a very good order because it can be enforced. What that means is if the other party, after you made this order, if they breach this order, which means they didn't go ahead with the agreements you decided, you can actually enforce it, which means they could be given a sanction, which is a warning. They could be fined. They could have to do community service, or they could actually go to prison. So that's why the order is a very powerful order. It's a very good order to have in place. And it essentially states who the child can live with, where they can live with, when you can have contact, if that's the weekends, who can have the children for holiday, when will they have the children for holiday, and different things like that can be addressed through this court order.
So with this child order, can it be only done at the court, or it can be done at home, or paperwork, or can I say, oh, I don't want to be at the court, this child order, can I just sit down by application and do the child order, or both of us needs to be at the court?
So with the child arrangements order, before you can even go ahead to actually do this order, you actually have to attempt mediation. So mediation is when you have a middle person who's very neutral. Their job is just to listen to both parties' queries and issues and to help them come with an agreement. Sometimes they might do like a parental plan to say this is what we want to outline in regards to how we're going to raise our children. But it's not a court order, so it can't be enforced. Which is why most people, if they do mediation and it's not successful, they will then go ahead and apply for this child arrangements order. This child arrangements order can be done online. So it's an application that we do for our clients. You do it online first, and thereafter it's a long process preceding that, because it could lead to a court hearing thereafter, which
when you
most
say long process, is it 6 months, 2 months, 3 months, 4 months?
It depends on the case, but I'm going to be honest, it could take up to a year in some cases, depending on the facts of the case, because they really need to assess what is in the best interest of the child. When we're looking at these things, the courts prioritize the child's best interest. So that's what they will really assess. That's why sometimes it can take up to a year or longer, because there's a lot of facts they need to go through and make sure they're making the right decisions for the child. Yeah.
So throughout the whole year, Abinelle solicitors can help such a person to go through it till the end.
Yes, we
Okay.
will be with them throughout the whole process.
Okay.
All the applications that need to be done thereafter. When it comes to attending the courts, we also coach them, to be able to speak and say the right things when they're there, so they're more at calm and peace and know what the process is like. So we assist them throughout the whole thing.
Wonderful. Thanks for the great explanation. Thank you so much. Lawyer Amy, someone is asking a question here. My children wants to spend more time with me, but my ex-partner isn't listening. What can I do? Can Abinelle solicitors help me?
Yes, children want to spend more time, okay, but ex-partner does not agree. That's a very good question. Thank you for asking, MDA. Yes, if the party that the children ordinarily live with has, is with the children, and then of course the parent that is outside the home now wants to have contact with the children. First of all, the courts will always want you to try and settle the matter amicably.
Okay.
Preferably amongst the two parties. So you try and negotiate and try to settle between the two of you.
Yeah.
However, as my colleague Shewa has mentioned, if after you have tried to settle amicably and it has not, materialized into anything productive, then you need to use mediation, where they'll try and mediate between the parties to get the desired result, which would be to see the children. Should that fail, usually the mediator will give you a certificate that you can now present to the court to say that you have tried to use alternative dispute resolution, but unfortunately that has not worked. So that would be the order in which this person would have to go through the process before they can say they're going to court to get contact with the child.
Okay. All right. Another lady is asking a question. I was separated from my husband, and the arrangement was that she stays with her dad. We are back together. We were separated, but now we have come back, and we think we love each other, and we want to stay together. We are back together. Can the arrangements be modified? Can the arrangements be modified?
Yes, of course. If both parties are now in agreement, the family unit is back together, then there would be no need for the court order anymore. Actually be no need. We can definitely inform the court that there's no need because the parties have reconciled, and therefore that should be considered, in light of the whole case. Okay. So that can definitely be done.
Okay. Does it take a long process? Is once you tell them that's it?
Once you tell them, that should really be about it. Of course, it would mean that, the court order, there wouldn't be a pressing need for a court order for anything to be enforced because the family are back together again. So that's good news. There would be no need for court orders,
Okay, thank you, Lawyer Amy. Thank you so much. Please, can you tell us your telephone number, your address, in case someone is watching us and they want to book an appointment with you? Can you please tell us your phone number and the address, please?
All right. Okay, thank you. Our phone number is, the landline is 0203 759 3309. And we have an office mobile that's 078 24 705 353. You see, we have an alternative number. If you want to get in contact with Shewa, you can call 078 17 679 235. And of course, we have our 24-hour line. Our 24-hour line is 07943 235 364.
Thank you, Lawyer Amy. So if you have any immigration issues, any family issues, the best place to go to is Abinelle Solicitors. Let me tell you, you will never go wrong going to Abinelle Solicitors. Whatever you are going through, the way they will speak with you, the way they will talk to you, the way they will explain things to you, even if you can't read or write, they will support you, they will help you. Abinelle Solicitors, timely intervention, excellent results. Okay, Lady Shara, if there is no contact with a British child, can I stay in the United Kingdom? There is no contact with a British child. Can I stay in the United Kingdom?
So with this question, it depends on if you're trying to do your application through the parent route, which they have clarified in Appendix FM some eligibility requirements, and one of those is relationship requirement. So if you are the parent of a child who's a British citizen or has a settled status in the UK, you actually have to show, that you have a genuine and subsistent relationship with that child. And one of the ways and some of the evidence that they require is direct access to that child, which you can do through a court order.
Okay.
This is why we're now talking about the child arrangements order. So there will be a few questions I would ask this person, to be honest, to find out a bit more about why they don't have contact.
Okay.
So if it's a case of they want contact with this child, then I would advise that they go ahead and maybe seek from the other parent they can have access to this child. Just simply call them, maybe try and arrange something to have access and build that relationship with this child. If the parent is proving difficult and you really want to have a relationship with your child, then we'd advise to go ahead through mediation and then the child arrangements order to be able to have access to your child, because it's very important that you can show the court that you have a subsistent relationship with this child. That means you regularly contact them, even if you can't see them face to face. You could have regular Zoom calls. We're in a digital age. You can have regular Zoom calls with them. If you have a FaceTime appointment with them, if you can't see them face to face, but you can show that you build a relationship with them. Maybe you send money every month. Maybe you attend parent evenings or extra curricular activities, but you need to show that there is a relationship with this child. And if you're having issues with showing that, then we would advise, if you really want contact with your child, then go ahead and apply for this child arrangements order. So it will be very hard to do an application based on, parent and child relationship under the Appendix FM if you can't show any
so
relationship.
I've got two questions for you. Let's say I'm not working, but I still want to see my child. Am I allowed? Me not working, is it going to be a problem, or it doesn't matter?
No, it doesn't matter. It doesn't matter if you're working or not. You can have access to your child. Some parents don't even work, and all they do is look after their child. So it doesn't affect your application if you're not working.
Okay. Some parents, once they are divorced, let me use the lady. The lady can say, I don't want you to go to your father, even though there has been a child arrangement order. And then I want to see my child, but the child says, I don't want to go to my daddy. I don't want to go to him. I don't want to see him. I want to see my child. What do you do?
Okay, so with this, you said there's a child arrangement order in place. So the main thing, like I mentioned before, that the court are very keen on is what is in the best interest of this child. So we've had cases where there's a friction between the parents, and sometimes it causes the child to side with one parent than the other. But when the courts, they have CAFCAS, which is like social services, they will call the parents, they will speak to the children, they will really assess the situation, and they can see it from an objective view to see what's really going on. So they can see when children are being manipulated by their parents. So they will be the one to assess the situation when you're making this order, and they will determine what is actually in the best interest of the child. They take into consideration different things. So it could also mean the age of the child. So if the child is really young, they can't really decide who they want to be with.
So
They don't
it's
have,
there. I'm telling you, it is there. Some of the children can even lie. This is what some of the parents do. They tell their children, oh, when I go to daddy, this happens and that happens, and I don't want to go there anymore. And you, as a parent, you want to see your child. So if the child is saying, oh, I don't want to be there. If I go there, daddy doesn't give me food to eat. He doesn't take care of me. And even sometimes when they are being questioned, they say it's true. When I go there, there's no food for me to eat. In that case, what would you do? Lawyer
yes.
Amy. So, sure, rest for me. Lawyer Amy.
Hi.
Yeah.
In what case, what would you do when a child is alleging
The
that
child is
somebody
saying, in Yaja, don't, I'm not going there anymore.
Not
Because
going
when I
there.
go there, the way they treat me is really bad.
Okay.
Meanwhile, it's not true. It's just the mom that has told him or her to say that. So this child is saying that. And even when the child is being questioned, he's still saying that, oh, I don't want to go there. Can this child arrangement order, what is the person going to do at that particular time?
Well, as my colleague Shawa mentioned, this is where the officer, FAFCAS, they're officers to the court, okay? This is where they get involved and try to find out what's happening. My colleague also mentioned that it's the welfare principle that is paramount, which means that they look at the best interest of the child and what the welfare of the child really is, what it entails. So they will make sure they do their investigations as to whether that possibly could be true. To be honest, it's very difficult to tell whether that is true or not because there's no evidence. But they'll look at things like the child's age, They'll look at things like the child's behavior generally. Do they behave in such a way that there are always things that are being alleged, and it's not like it's exactly happening, So these are things that they will look into, and they have that time. They have the time to really go into detail, go to the school, check with the child's GP and so on and so forth. Make sure it's a founded claim. Sometimes some of these claims even end up, some of these things they end up with the police. What they can do is they will request for police evidence to be provided, as well. So NDA is not something you can just say with, say it and the court just believe it like that. They do their checks. They make sure they do the checks because these things do happen,
Have you ever had a case that they would say, oh, we are not going to allow the mother to see you again for now because of what the child is saying? Have you ever had a case like that?
We haven't had a case like that, but honestly, there are cases like that.
Okay.
And the reason why they would come to such a conclusion is because of course, it's a founded claim. Maybe they go to the police, they go to the GP, they request information for police disclosure, they go to the GP. All evidence is pointing in, to the fact that the child is being maltreated, the child is being neglected. Police have been called. There's been injuries. Maybe when a child attends father or mother's house, there's injuries. Maybe the child there's malnutrition. That's been recorded with the GP. All of which they could, the courts can stand on and say that one parent should be excluded from the child's life at a particular time. So it does happen.
Okay.
It does happen, yes.
Thank you so much. I've got another question for you, Shawa. What if I have made an application for child arraignment, but the case has not been concluded yet? Can I still put in an application for my leave to remain?
Yes. So with this, we would advise that they can still put in an application.
Okay.
I think what's very important with this application, when you start the child arrangements order, you're going to already have a few documents in place. So if you attempted mediation, you already have that certificate in place that shows you've already attempted mediation to have access to your child. That shows a genuine, intention to have a relationship with your child. So that's something that you can put as evidence. And also you already have different documents that you've received during the child arraignment order application. Because like I mentioned, it could span for a long time. So you'd already receive maybe a cash report that shows that this is a hearing that's about to happen. You receive directions from the court, all of which you can put in support of your application. And if you have anything prior to this, if you have the birth certificate, your name is on it, you can also include that in your application. Anything that you have that shows you had previous contact with the child before maybe there was an issue with the other parent, this can still be used in addition with your application. So I would say they still have a very good chance of doing this application without the final order.
Okay. There's another question. The father of the child has refused to give me the birth certificate and British passport. How can I make an application for leave to remain without such important documents? He's refused to give it to me, and I have to do the application with it. What do I do?
Yes, so this is a very difficult situation as well. I can imagine how they'll be feeling, but there's still hope. So within this child arraignment order, there's certain orders you can apply for. One of them is a specific issue order. So this order will address any immediate issues that you might be having with the other parent that you want the court to address. So one of those things would be not having access to important documents of your children, like what you just mentioned. Sometimes it may be not even being able to have access to their schools. We've had someone not being able to have access to the school or being able to go to GP appointments that they wanted to attend for their child. So in this specific issue order, this is what you'll be outlining to the court, and you outline the past history of what's happened and why you want them to grant this order for you to have access to these documents and why that's very crucial and important. So that's an order that you can put into place that will allow you to have access to these documents.
All right. Thank you, Shawa. Thank you so very much. You are really explaining to us, and I think people are really enjoying it. The best place to go to for your immigration and family issues is Abinelle Solicitors. Timely intervention, excellent result. Let's go for break for a minute or two and come back. Thank you.
You are always welcome home, welcome.
Today's news is about success stories. Ever since we introduced Abinelle Solicitors to you, there have been countless impactful stories from our clients. So if you are yet to experience the most promising law firm in London, welcome to the world of Abinelle Solicitors, where there's always timely intervention for excellent results. Abinelle Solicitors, we specialize in immigration and family law. So for immigration, come to us for nationality law,
EEA law, leave to remain, point-based system applications,
entry clearance applications, student visas, visitors visas, and all appeals and judicial reviews. And for family law,
come to us for divorce, separation, consent orders, child arrangement orders, financial orders, and mediation.
Come, let's do business. Our address is
14 Claypole Road, Stratford, London, E15 2RJ.
Please call 0203 759 3309 or 078 2470 5353 or 077 8732 7985. Our 24-hour emergency contact line is
079 4323 5364. Email info@abinelsolicitors.co.uk.
Abinelle Solicitors. Timely intervention, excellent result.
To where you are always welcome home, welcome.
Today's news is about success stories. Ever since we introduced Abinelle Solicitors to you, there have been countless impactful stories from our clients. So if you are yet to
You are always welcome home, welcome.
Today's news is about success stories. Ever since we introduced Abinelle Solicitors to you, there have been countless impactful stories from our clients. So if you are yet to experience the most promising law firm in London, welcome to the world of Abinelle Solicitors, where there's always timely intervention for excellent results. Abinelle Solicitors.
You are always welcome home. Welcome.
Today's news is about success stories. Ever since we introduced Abinelle Solicitors to you, there have been countless impactful stories from our clients. So if you are yet to experience the most promising law firm in London, welcome to the world of Abinelle Solicitors, where there's always timely intervention for excellent results. Abinelle Solicitors, we specialize in immigration and family law. So for immigration, come to us for nationality law,
EEA law, leave to remain, point-based system applications,
entry clearance applications, student visas, visitors visas, and all appeals and judicial reviews. And for family law,
come to us for divorce, separation, consent orders, child arrangement.
Hello, everyone. Thank you all for watching and staying tuned. And once again, this is Time with Abinelle Solicitors. Okay, Shawa, I've got another question for you. The mother of the child claims that the child is not mine, despite passing off my daughters as my own for 8 years. She therefore says she will register the birth of the child to reflect her true biological father. I believe this is a tactic to ensure I am unable to renew my leave. I heard through the grapevine that her new partner is claiming paternity of my daughter and conveniently wants to use my daughter for his stay in the UK. Please advise.
Okay, this is a very good question. It has a lot of things to discuss. I will speak briefly and then I'm going to pass it over to Amy to just go further into it. So from what we're saying, this man believes the child is his, and I believe his name is already registered on the original birth certificate. So of course people can actually re-register and change the birth certificate. So in this case, if he's already on the original birth certificate, it shows that he has parental responsibility, which means he already makes very important decisions in this child's life and should be able to go ahead and do his application with the birth certificate. But if he really wants to find out, who really is the father of this child, he would have to do a specific issue order for a DNA test to really get the true paternity of the child. But one thing to know, even if this man is not the father of the child, but he has played a very huge role in this child's life, and he's taken on the role of the father, and he can show that he has this genuine and subsistent relationship, that does not stop him from applying as a parent or step parent of this child. Because we've had cases where someone is the step parent of a child, but they have stepped into the role of that other parent who's no longer present, and they've still been able to get their leave to remain through that route. But Amy can enlighten us.
Before Lawyer Amy continues, please, if you are watching us live, can you please share and invite people to watch as well. You'll be helping someone. Please do share the program if you're watching us live. Thank you. Okay, Lawyer Amy, please, can you...
All right. So, okay, thank you, Shawa. So, yes, with this application in particular, like my colleague mentioned, you'd have to make, if the other parent, which is the mother, is claiming that father is not the biological parent, and she is re-registering the birth of the child, these are all steps that are being taken, without the obviously the original parent that was on the birth certificate's consent. You would even need to get their consent anyway for re-registration. But if this issue is being contended, the best thing you should do is to go to the family court and apply for a specific issue order for a DNA test, for father to undergo DNA testing with the child to get the paternity of that child. Because if the alleged father is now stepping into the arena, let's say, and he's now saying that he has PR, parental responsibility for the child, there can only be one father. So if both of them are claiming that parental responsibility, the only way to find out is through a DNA test. So it's very important that you go back to the family court. Because it's not all the time you get somebody to subject a child to DNA testing. Maybe they may say no, maybe there might be a bit of contention there. So if you go through the family court, that would be the right way, the formal way to request for DNA samples to be taken, for a DNA report to be, prepared. Okay, so that's very important. Now, DNA, once, somebody's contesting paternity, DNA will sort of override everything. If it comes back and the father is indeed the father who was originally on the birth certificate, of course, Home Office will be very happy, providing that father is actively involved in the child's life. They'll be very happy to grant him leave. However, was explaining something that even if it comes back and it shows that, in fact, unfortunately, the original parent, which is the father on the birth certificate, is not the father after the DNA report has been produced, there's still a way around it, because the way around it is you be applying outside the rules, using exceptional circumstances. If it can be shown that you're still, you're still actively involved in the child's life, you haven't been cut off, you still go to parents' evenings, you still participate in their extracurricular activities, they formed a strong, loving bond with the child. Of course, we have to remember that they look at the best interests of the child, even in immigration cases. So the question is, would it be in the best interest of the child to sever such a relationship? A father they have known for so many years. It could be 5 years, it could be 10 years. You've now introduced a new father into the equation. But remember, if that relationship with the father that they've always known is severed, it will have an emotional and psychological impact on the child's upbringing and development. And that is what they want to try and avoid. So this is still a case that can be handled, and you could still end up having leave to remain based on exceptional circumstances in this case.
Thank you very much, Lawyer Amy. Thank you so very much. Someone is asking another question here. My ex-wife, who currently lives in London, wants to relocate with our 2 children to Doncaster. I'm on the 10-year parent route. I disagree with the move and want to stop it from happening, as I know I would be unable to see the kids often.
Yeah. So this is something that happens to a lot of people. They've been with someone and the other person has the children or the child, and they want to relocate. So the person has a say in the upbringing of their child. Yeah. As mentioned, he's on the 10-year parent route, so he's already shown to the Home Office that he has a relationship with his children and he's on that route. So what he can do, he can actually apply for a prohibited steps order. That can also be done within the child arrangements order. What this simply means, it prevents the other parent from making a decision without the permission of this parent, the other parent. So for example, like you said, the person wants to relocate. They will not be allowed to do that if the other parent doesn't consent for them to do that. So essentially, like Amy was mentioning, there's a lot of things that the court take into consideration with children in regards to their best interest. Is this relocation even in the best interest of the child or the children? They're being moved to a complete different area. They might have already started school, formed relationships with people. So these are things that they will consider, even the relationship they have with their father. You can't uproot them from something that they're very used to, they know that's helping their development. It can affect them, like Amy was mentioning emotionally or psychologically. So these are things that the court will consider when you're making this prohibited steps order. And they might also say this is in favor of the children, because you can't just uproot them to another location without consenting from their parent, and seeing how this will impact their lives so far. So it's something that the person can definitely do, and it'll probably work in their favor.
Oh, okay. Thank you so much, Shawa. Someone is asking on the comment section saying, when do I apply for the court order? Is it immediately we get divorced, or we get some time? Maybe I can pick them when I want to. We have agreed among ourselves that I can pick them anytime I have to. Do we still need a court order?
So you can do it during the divorce process. You don't have to wait till after. So you've already separated, for example, if they've already gone through separation, you can start the process. But like we mentioned before, they do need to attempt mediation. However, if they attempt mediation and they both agreed on this arrangement, then that's also something they can go ahead with. But people change their minds all the time. So that's why we always say you have to attempt mediation, but if it's not successful, we'd advise to go ahead with this court order, because if they change their mind, there's going to be consequences, and not everyone wants to be fined or have to service. So if they do it the first time and there's a sanction in place, I doubt they'll do it the second time. So we always advise to go ahead with the order eventually anyway.
Okay, sure. So let me give you this scenario. Let's say I've been given a court order. I pick the kids during weekends. Now, I've remarried, and it looks like my wife doesn't want to see the children, and she doesn't want the children to come to me, and it's causing a lot of troubles. Can I just change my mind and say I want the children to be there? I can't pick them during weekends. You stay with them, and if I want to see them, maybe I'll meet them at McDonald's, or which it happens. That's why I'm asking. A lot of parents can't go home to see their children. They meet them at KFC, McDonald's, Nando's. So can I have a change of mind? Even though the court order has been done, can I have a change of mind? I can't pick them on weekends. Is that possible?
Yeah, so just like you mentioned, in general, things will happen in people's life that change it. So they can amend the court order, but they will have to obviously let the court be aware of the changes that they want to make. And then they will essentially reissue a court order that outlines exactly what they want to change and the new things that they have in place. So it's amendable.
Okay, Shawa, this is going to be my last question for you, not to Amy, for you. So, let's say I want to come and see Abinelle Solicitors. I can't read. I can't write. You know, a lot of people, when there's an application, they just write things, and that is how they are being declined and refused. So now I don't want to do it by myself because I don't know what to write on the paper. I don't even understand some of the words or terms that they do use. When I come to Abinelle Solicitors, can you help me do the application? Because on the radio the other day, someone was mentioning about Shawa, that he came to you, mind oh mine, what you did for him from A to Z. You did so well, and he had a positive result. So I want you to say to people watching you right now, maybe they can't read or write and they want to come to Abinelle Solicitors. Can they come? Do you do that? Do you help them to do the applications? They can't read and write. Can you support them?
Yes. So like you say, timely intervention. We are here to help you through the whole process. We are whole package firm. We don't just, start and then we leave you. That's why it's very important we understand your story, we listen out, we ask questions. When I'm working with clients, I really want to understand exactly what the issue is and how I can help them. It's very important to understand how I can help you. Every case is different. So that's why we always take that approach when working with our clients. And we take our time. We're very patient. You can call us at any time. We're here to help you. That's the whole point of this profession, to use our own skills to help people who cannot help themselves. So that is exactly what we do here. And if you have any issues along the lines of everything we discussed today, or just separate to this, anything immigration, family, we are here to help you. And by God's grace, we get excellent results at the end of it.
Thank you, Shawa. Can I just say something to people watching us or wherever you are listening to us from? Please, Abinelle Solicitors, they are the best. Go to them, whatever issue you are going through, immigration and family issues. Please go to Abinelle Solicitors. They are the best. They have time for you. They listen, whether you can read or whether you can't read or write, they will support you. They will help you throughout. And do you know what I like about Abinelle Solicitors? They always have excellent results, positive results, because they are the best. It doesn't matter where you are, just call Abinelle Solicitors and they will help you throughout. Everyone loves Abinelle Solicitors, and keep watching us every Friday at 5 p.m. UK time. Shawa, say something to them before you go.
Yes, thank you all for joining us today. I really hope that it's been helpful and insightful. If you have any issues, like we mentioned, in regards to immigration or family law, or anything you're not sure of, we are here to help you and to support you as best as we can. Thank you for joining us today.
Thank you so much. Thank you. Loyemi,
Hello.
have you got something to say?
Yes. Thank you. Once again, thank you for tuning in this very Friday. It's been a pleasure to host such a lovely show. Please tune in next week. We have very interesting developments in the law that we are going to discuss with you next week. So please tune in and do have a blessed weekend.
Loyemi, someone is asking that if they want to contact you and he finishes work at 8 o'clock, is it too late to call, or is okay?
No, it's not too late.
It's not too late. Okay.
You can call my number, which is 078
Okay.
24 705 353, or in the alternative, you can call the 24-hour line, which is 07943 235 364. Give us a call anytime. We will be here to be of help.
Thank you so much, Loyemi, and thank you, Shawa. Thank you all so much. So, next week, Friday, I'll meet you all the same time. My name is MDA, Mamadan Kwasante. Love you all. Once again, bye-bye.
You are always welcome home. Welcome.
Today's news is about success stories. Ever since we introduced Abinelle Solicitors to you, there have been countless impactful stories from our clients. So if you are yet to experience the most promising law firm in London, welcome to the world of Abinelle Solicitors, where there's always timely intervention for excellent results. Abinelle Solicitors, we specialize in immigration and family law. So for immigration, come to us for nationality law,
EEA law, leave to remain, point